Please take your seats and listen as Donna Cornell talks about ethics, and if we have time, we're going to also be getting into sexual harassment and implications thereof. Rather timely topic.
Good afternoon. I am going to talk to you guys today about ethics, conflict of interest, all those fun topics. And because of all the events of yesterday, it occurred to me that it might be a good idea for me to throw together a few slides on sexual harassment. So I have another set of slides that I've put together this last night and this morning that I'm going to get to when we get through with the conflict of interest piece. First thing I will tell you, because we loaded the slides from last year's slides, I do have an updated set of slides which are not the ones on your flash drive, but the ones that are on the website are the current ones. So if you will refer to those, the law did change a little bit as it relates to state institutions. The first thing I'll tell you is that the law is not exactly the same for the local governmental entities, the community colleges, and for state institutions of higher education. But generally speaking, they're the same. I mean, if you were going to kind of condense it down, in my way of thinking, it's if there's a potential conflict of interest, you disclose it and you recuse yourself. That's the short. I could be done with it there. But I'm a lawyer until we talk a little bit. I've got some should nots up on this slide. Just the Ethics Commission, you would think, and that really is more relevant to state institutions of higher education. But I will tell you the same premises are going to apply no matter what. It's really, if it feels wrong, it probably is wrong. Again, it doesn't get more complicated than that. But the legislature, in its infinite wisdom, likes to lay things out, and they create organizations like the Ethics Commission to give you a little bit more guidance. So these are the kinds of things that you would expect to create a conflict of interest. Generally, if a reasonable person having knowledge of the circumstances would conclude that a conflict of interest or the appearance of a conflict of interest exists, that's a conflict of interest. But absolutes don't always work, and so the law, as it has evolved, including this last session, basically says if there's some kind of compelling benefit to the institution, there are ways for the conflict of interest to be mitigated. It never is eliminated. What we do for conflicts of interest is we manage them. And you would ask, what does that mean? How do you manage a conflict of interest? Well, you try to, if you are the one that has the conflict, you kind of step back and take yourself out of the equation. So if it is a board or your board would ask you to recuse yourself in some situations. If you had some kind of financial interest in the matter, you could be asked to leave the discussion. It's not required by state law that you would step out of the discussion, but some organizations like the Association of Governing Boards, their best practices would tell you you should step out. I will say that does not always occur, and it's not always necessary for it to occur, but just so you know that that's something people will definitely be talking about. The most common types of conflicts of interest for any board member is going to be financial, and those are the things that get headlines, gets you on the front page of the newspaper. Again, as Kabi says, all bad, and I agree with that. It's not a place anybody really wants to be. Contracting with state universities, you must disclose a conflict of interest with regard to any known financial interests regarding the contracts or the bids. The law, again, has evolved. We went through some craziness in 2015, so we had very strict rules that the legislature had imposed, and there was conflict in the statutes. They cleaned it up this last session, and now this is the how you manage the conflict. This is the statute that governs for state institutions of higher education. So if the board member has a substantial interest in the business entity, they disclose, refrain from voting, and the board must approve the contract by majority vote. And again, you would put in your minutes, ex-board member, ex-trustee has recused themselves. So whoever is the chair or whoever is calling for the vote would make that statement into the record. This defines what a substantial interest is. Again, it's all technical, and it's going to be a little bit different based on whether you are a trustee or a regent for a state institution. But again, you know, it's technical. I would ask my lawyer, is there a real conflict? This is my financial interest. Let somebody else make that determination as opposed to you. But just, you should be aware that there are very specific rules about what would constitute a substantial interest. It's within 1 degree, so it's not just you. For state institutions, it's also can include your family members, and that's what they call within 1 degree of consanguinity. That's the blood relationship. It's different for community colleges, then it's within 2 degrees of consanguinity. It gets complicated. Again, I will tell you, go back to your lawyer and ask, does this constitute such a thing? Former state officer or employee of the university who during the course of the employment participated on behalf of the university in that negotiation, you can't go then work for that entity that you have gotten business for. Local government code. Again, disclose. You are a requirement of disclosure, which is the same as for state institution. There's an additional requirement where vendors also have the affirmative duty to disclose. And there are not criminal penalties, but it's still a violation of the statute. Requirement, enter into the contract if you have the relationship, if you has anyone in your family, or have you been given a gift within the previous calendar year, then that would constitute a conflict that must be disclosed. The required forms are on the website of the text. You have to, on the community college side, those disclosures have to be filled out by form, right, Kavi? And those, same with the vendors, and so those are then filed. Here the disclosure explains you have to be as an officer or own at least 1% of the company. Again, it's a little different, state to local government entities. So you want to really be sure what you're disclosing and if you need to disclose. Here, the family members, the definition is a little different because it goes further, because you add the following relatives, it goes further down, it goes to the 2nd degree of consanguinity. So if your aunt was given a gift, or so it gets complicated. If you have a question, ask your lawyer. It's just, all the information is there. You can find it on the Ethics Commission website, but I would ask rather than just try to rely on it myself. Before I get to hypotheticals on this, I wanted to speak to you a little bit about gifts generally. And can you take it? And going back to the should nots. You can't take gifts, favors, service that might tend to influence you in your decision. A gift does not include typically token gifts. What the Ethics Commission has defined token gifts as $50 or less. Typically, you can go for a meal with someone. On the other hand, you can't take a bribe, and some would argue, I will tell you, people out there would argue that even, taking some big fancy meal from someone, even something less than $50 could constitute a bribe in some people's mind if it was done to induce you to enter into a particular contract. Each board has their processes a little different. And my institution of higher education, my board members do not vote on a particular vendor. I know that is not true with all of you. And some of you actually delve down and make the decision on who the particular vendor is. My version of best practice is it's better to delegate that to the administrators, but I know that's not necessarily how everyone operates. And so that is where you can get into more complicated issues. Right, Cobby?
Yes.
You can't accept employment or engage in professional activity that might have you disclose confidential information. You cannot accept employment or compensation that might impair your independence of judgment. You should not make investments that could create a conflict with your public responsibilities. So there might be times when you see an institution that has an endowment and you as a board member are voting on where to make those investments. You're a chair of the endowment committee, and then you decide to get in on the action, so to speak. That can create a conflict that would be inappropriate. Ultimately, you should not be accepting benefits, financial benefits, that are given to you for the exercise of your official duties. So with that being said, I do want to go through a couple of hypotheticals, and I am mean that I do call on people. If you all don't volunteer, I will call on you, so just be forewarned ahead of time. And I will point you out. I will try to get my folks to answer the questions, but I think this is the most helpful part of the discussion, because I want to try to walk you through things that are going to happen in your life. So let's say a regent or a trustee owns stock in 1% of stock, or more than 15,000 of the fair market value of a national office supply company, which regularly provides supplies to the university or college. Is that a good idea or a bad idea to be involved in that? Bad idea. Do you think it matters if the company historically has always been the entity that has been selling to this particular institution for years, maybe even before the regent or trustee became appointed or elected? What if the university held, or the college had, this contract, and then you become on the board or the trustee? What do you think happens then? Yes, sir.
You disclose your position.
Here, let me get you the mic because we're recording. Oh, yeah.
Now no one's going to talk.
You disclose your position, as well as if there's something that comes up and there's some decision you have to make, some discussion, you abstain from that dialogue.
Do you think you would still be subject potentially to criticism for that?
Probably so.
You're approached by an alum who's also an architect, and he wants you to help him in his bid to land a major university or college project. What do you do? Let's start with that. I know that would never happen in your world, but let's start with, what would you do? Yes, sir.
Hold on.
Here we go.
Would that not fall under the Professional Procurement Act?
Yes.
So, I mean, then you can put in a good word for that person.
Should you put in a good word for that person?
Yes. But it's not a bid. It's a discussion as to who's better choice to do the work.
Right? Do you think you could be subject to criticism for promoting one architect versus another?
Yeah, you probably could. I mean, you got to choose somebody.
Facebook tomorrow.
What do you think, Fernando?
I'm thinking of begonias. I mean, you know, you're a sitting regent. This is a friend of yours. You say this to somebody. That separation can't be made. I really would avoid that.
He didn't say friend, he said alumni.
Alum.
Pardon?
Alum. What if it was an alum?
Alumni, it doesn't say friend.
Okay, so what if it was a friend? Do you think the answer would be different?
Yeah, I think. Yeah, if it's a friend, if it's a friend of yours, then you should probably recuse yourself from any decision on that.
My general advice is when somebody comes to you and wants you to make an introduction of a particular vendor, you know, the University of Houston does a lot of construction, as some of you may be well aware. And there are many times, and I know you all do a lot of construction, and there will be particular vendors who want to build XYZ building. And they're going to come to you and say, can you help me out here? So my advice always to my board members, as well as my vice presidents, my vice chancellor, anybody involved in the procurement process. Number one, if it's your friend, you need to stay away from that. And number two, if it's somebody that's not a friend but just wants to have an introduction, you refer them to the people that can explain the process to them. You make the introduction to whoever it is, the procurement officer or whoever is responsible for that process in your organization. You make the introduction, you give them information about how to go about bidding on university or community college projects. That, to me, would be the best approach.
Is that different for your employees versus your board members? Would you invite the board member to go to a chance with the president, or would you have them just make the handoff?
The question was, would it matter if it was another employee providing that, wanting to provide that same information? If it is somebody that is on the procurement process, they should not be involved in having a discussion with any of those potential vendors outside of the specific process, so there should be no discussion. If it is anyone else, I would, again, send them back to the process, because that's how you protect the institution each and every time. Yes, sir.
I have two questions. So the previous example mentioned regents. I assume that applies for trustees as well?
Yes.
Okay, so in that case, I was surprised with the $15,000 number, and I'm sorry I tried to get your attention before,
Sure.
but I'm sure a lot of people in this room have $15,000 worth of Microsoft shares, or in mutual funds. That's a very small number. I knew about the 1% of a publicly held company. That's the number I had in my head. Is it really $15,000?
That's the language in the statute.
That's what the legislature is.
That's what the legislature has determined is a substantial interest.
So if you had $15,000 of Microsoft shares, you couldn't approve any of the Windows or computer purchases?
Correct.
You should be recusing yourself.
Just wanted to check that. Okay,
Yes.
thank you.
There's a question over there.
Yes. Yes, sir.
Publicly traded company have any difference? Make any difference?
No.
Technically not.
Okay, now that I've made everybody happy, let me keep moving along here. This is kind of a repeat of the previous question. The regent recommends their best friend, and this was the other half of the question we talked about earlier. This is where you're recommending a friend as opposed to the alumnus approaching you. What would your role be in voting on the project? Again, send them to the process. The best practice would be to recuse yourself. I think we kind of went through that one already. Great. You received a call from an unhappy vendor whose company missed the bidding deadline by 15 minutes, and believe me, this does happen. You have reason to believe this vendor is the most qualified and could create significant savings for your institution. What do you do? Who's got an answer for me? Kabi, have you got an answer? What do you do?
I was looking at another question.
Okay.
Sorry.
Bill?
Turn down all the other bids and reopen the bidding.
What do you think, Fernando?
I think Bill's solution is probably the practical one, but I would certainly not waive the 15 minutes.
No.
Or the 1 minute.
You would close down the process and reopen the whole thing.
I think that would be appropriate.
If you're convinced that they're the best and the others can't do it or can't do it as well or can't do it, you know.
Yes, ma'am.
Are we talking about the perspective of the board member? This is a board member that's doing it?
Yes, I will tell you that board members, the vendor knows you personally for some reason, and they're going to call you and ask you, this is ridiculous. I could save the university or the community college millions of dollars if you just select me, and you're convinced that's true.
But yeah, I'm just saying from a board member's perspective, I would not advise my board member to get involved in that situation.
You'd send it back to the...
I would give it to the president of the administration and then let them make the decision to then ask the board to reject all of the bids, and then you could reopen it if the procurement office felt that was the appropriate thing to do. But I would advise the board member if I really felt that wasn't, and that firm was just pulling his leg or her leg.
Well, and again, to remember that as an individual board member, we have no authority.
Correct.
It would have to be the board that would make that decision if staff made that recommendation to start the process over again. But basically, it's a hard and fast rule. You snooze, you lose.
Yeah.
And how do we know that there would be significant savings? Because we don't have privilege of knowing what the other bids are. And just another comment, in the Dallas system, we're very fortunate. I've always said I don't want to end up in jail. So we have a very strong firewall on the bidding and contracting, the procurement processes as a whole. The only involvement is it coming to us. We question if it's the best deal for the district. Other than that, and vote on it. Other than that, we can't touch any of it.
Agreed.
Well, and you probably have rules that they shouldn't even be calling you to say.
Correct.
Exactly.
Yeah.
So here's the thing, kind of some of the advice that I heard. So what if the board does just say, well, we're going to reject all offers and reopen it? As the person who handles all the public information requests at the college, what does the college have legally when the vendor who went to the board maybe in the first place, that the board rejected it, is now filing a freedom of information request, just saying, I want to see everything. I want to see who knew who, and I want to see the emails, and I want to see all of this documentation where the process was usurped.
Correct. Well, usurped. So I'll say a couple of things. This does raise the question. This hypothetical does raise the question of what is a management function and what is a governance function. Your governance boards, this is a management decision. So number one, I would agree, you refer this back to the administration. Does it happen, in all procurement and in all things, as practicing law for the last 31 years, there are no absolutes. I can't ever give you an absolute, if this happens, that happens. It just doesn't work like that. So there are going to be situations just like this where you will have this phone call and you might open up the bidding again. There are always going to be administrative processes that allow for circumstances like this. And yes, you could be subject to an open records request. That's just something you have to deal with and make sure your documentation is very clear why you would open it up again.
Okay, this is how it gets to the board. If and this is the way I think if I had to deal with it, I would deal with it. It would get to the board because somebody in administration says, okay, this bid that came in 15 minutes late, there's really some substance here. It's not some vendor saying, well, gee, I submitted 15 minutes late, but I can save you millions. But there's been an analytical process that this is something that we might well consider because it would be in our best interest. You've got some bids, you want to take them to the board. I think that you could discuss with council. You can certainly discuss it with the administration, but you could certainly discuss in executive session with the board what the board's liabilities are by turning down the bids and reopening. Mm-hmm. And so that's protected stuff. And then that dialogue can take place in closed session, and the decision can be made then in open session whether to proceed or not to proceed. As far as public information, yeah, you're darn right. You better believe you're going to get a request, and part of the subtlety there is that this is an open process, and there may be some exceptions. You've also got vendors that are going to say that you've got trade secrets and confidential information, trade information that you're about to be released. So you're going to end up with the attorney, sending the information to the Attorney General's office and letting them make a ruling on it. So when all is said and done, you're going to be in a rather protracted, involved process, not only with respect to public information, but with respect to bidding. And so I guess you have to be really sure that it has the prospect of saving you millions before you decide to close it down. As far as closing it down, it's your prerogative to close it down. That's the third thing I'd say. As a board, you can't be sued. There's no contract. There seems to be no corruption involved. I don't know what they can sue you for.
Doesn't mean they won't sue.
Oh, well, they may, but they're not going to get very far.
Okay, I'm going to keep moving along.
Can I offer something?
Sure.
Over here. First of all, we have a policy that says that any contact like this has got to be reported. Mm-hmm. And that's to protect the trustees. Because our system has had a history of going afoul here, as Kabi well knows.
Sadly, yes.
But the other thing is the institutional credibility. You set up a bidding process that's fair, and that criteria is here. If you violate that in any way, you think in terms of what the impact it's going to have on your business community as they try to bid on your products or the things that you want. So again, institutional credibility comes into play there a lot when you make that determination whether to continue this thing or not. And to me, I would think you wouldn't. I mean, he's late. There was a criteria. It was public. It was published to everybody. And unless a guy had a heart attack or there was an accident that couldn't get him there, or the FedEx truck had a wreck or whatever, still, there are very few items that you could use as credible reasons to not continue the process.
Thank you. I don't disagree with you. Let's go with this one. You get a call from the governor's office insisting you vote against a tuition increase because the governor is concerned that it will hurt his reelection bid.
It's never happened. It's never happened.
I'm going to just take the easy approach here because I really do want to talk to you a little bit about sexual harassment, and I will tell you that, your fiduciary duty is to the institution. It's not to the governor. Your duty of loyalty is to the institution and not to the governor. Easier said than done. It's easy for me to say that standing here, knowing the political ramifications, but just remember that. Okay. Sexual harassment. I know this is a subject that may have an impact on your lives, and it certainly does, as you all are, every single one of you here are leaders of your institutions and in the communities in which you live and work. This is something that I've been defending sexual harassment cases for over 30 years, I know I've seen everything, and all the stuff that you hear today is stuff I've been hearing for the last 30 years and frankly experiencing through my career. It is something that you all need to be aware of. You need to know what the law is and the basic do's and don'ts. So I just thought I would go through briefly with you what sexual harassment is. It includes sexual advances, requests for sexual favors, verbal or physical conduct of a sexual nature when the conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. You know, there's lots of stuff for people to litigate on that. What is severe? What is pervasive? Those are things of long discussions and many court cases. The victim doesn't have to be of the opposite sex. The harasser doesn't necessarily have to be the victim's supervisor for there to be liability to your institution. It can be a coworker. It could be a supervisor in another area. The thing that's really important to realize when it is a supervisor, the institution is strictly liable, whether they knew or should have known, doesn't matter. For other harassment by coworkers and an employer will only be held liable generally if they knew or should have known and didn't take action to stop it. But if it's a supervisor, the institution is going to be responsible. That's why we settle cases. Title VII cases, the same cases under state law. There are statutory damages. We do not have sovereign immunity for those claims. A victim can be anyone affected by the offensive conduct, not just the harassed person. You can create a hostile environment by two coworkers having a consensual relationship, having flirty behavior, and impacting somebody else's work environment. It doesn't have to just be those two people that were involved in the relationship. It can impact everybody in the department. Unlawful harassment can occur without economic injury to or termination of the victim's employment. You can be liable for that regardless of the damage economically. The harasser's conduct must be unwelcome, but be aware what is welcome in a consensual relationship can easily turn into something else if the relationship turns sour. In institutions of higher education, in community colleges, I cannot tell you how often, and I don't know how many of you have consensual relationship policies. It's something that we struggle with. The University of Houston does not have one. I've always relied on the fact that we have state and federal law that prohibits this kind of behavior. So we have never designed to try to come up with a consensual relationship policy. The University of Texas has a consensual relationship policy where they go through this elaborate process to determine if there is the potential for a conflict of interest or creation of a hostile environment. I can't tell you what is the best approach. I'm just telling you how I've always advised my folks. It is something that in this day and age you all should be aware of. I would encourage each of these boards to consider these issues. The tone always comes from the top. It is very important that people realize that you as board members take these issues seriously and provide direction to your campuses on how to proceed. What do? Review your institution's sexual misconduct and harassment policy. Let's just take a look at it, make sure it's there, something that you understand, that you can communicate to your constituencies. This isn't going to happen in our organization. Ensure that your institution complies with the training requirements that are imposed by state law. Make sure that's something as board members I would really want to know. Ensure that there are clear channels for people to report. You all have heard in media of late under Title IX. You know, what did we do? Why did we fall down on Title IX, and why were we subject as institutions of higher education to so much criticism by Title IX and not following up on allegations under that law? The reason why it went so far is because there were no good avenues for the victims to follow through. And there were no adverse actions when people were doing things wrong. And that's how you go all the way, way over, and in some cases, violating people's due process rights, typically young men complaining, I'm being set up. And so you go all the way over to the other side because the institution didn't provide the redress for a true violations of the law. It's the same thing under Title VII or the Texas Commission on Human Rights Act, which is the state law version of that. You've got to make sure there are avenues for folks to report these kinds of things and that those investigations are done sincerely, seriously, and with discretion. It also means that you provide due process to all the parties involved. You don't railroad people, because that's just as wrong as ignoring those victims who have not had an opportunity for redress. What do you not do? You don't ignore it. You direct a complainant to the appropriate responsible employee with the authority to properly investigate the allegation. You don't try to unilaterally determine the credibility of a report. You direct it back to the folks that can make these kinds of decisions within your institution. It's something that board members need to take seriously. As community leaders, you need to take seriously and convey the message for each of your institutions. Signs that you might have a problem. I will tell you, these are all cases, some of which, I mean, it's like ridiculous, but I will tell you, these are all real. These are not made up cases. Some I personally handled. You see, an employee has put a bed on the floor of his office. The way that got reported was through our anonymous reporting system. We have an anonymous reporting protocol. And the details of all the behavior that was going on in some far off corner of the institution are mind-boggling. An employee presses another head between her breasts for fun. She thought that was a good way to interact with her employees. A faculty member insists their graduate advisees can only get advice over a glass of wine. Employee asks for a button to be installed under their desk to lock I made that up from last night.
I was going to say, is that employee's name Matt? By any chance?
Matt Lauer had it.
The supervisor offers free massages as he walks through the office. And then we have the office parties. Oh, I wish they were only social and everybody could just pretend, it just could be lovely. And there would be nice holiday spirit and everybody would be nice to one another, but oftentimes these kinds of parties can turn awry. Sexual harassment does not need to occur within the confines of the office or during office hours to be considered unlawful. I'm sorry to have taken your time to talk about this. It's something you all can tell I'm really passionate about, and I had the opportunity to talk to to folks that I have a lot of respect for the roles that you play in the state, and I just really wanted to take the opportunity to remind you of those responsibilities and how you can influence the outcome of this time in our community and in our state. So thank you very much.